Hello everyone, welcome to Court with Krissy. Here are 4 short court clips you probably didn't catch, and I'm kicking it off with Judge Dad. Warning, check your volume, or you might end up just like this defendant. Can you hear me now? I hope you like it. Court with Krissy is now in session.
Victor Paul Severinsky, 25W83769. Is Mr. Severinsky out there, Lisa?
He's in the front row, Judge. He's hard of hearing.
Oh, sir, how you doing? Mr. Severinsky? Sir, can you hear me? Wow. You're okay.
Where do you want it, Your Honor?
Sir, why don't you have a seat right at the table there? Wow.
Hang on. Hang on a minute. Right here. Have a seat right here.
Sit right there?
Right here.
He's really hard of hearing. I don't know how I'm going to be able to do this. Sir, your name? Sir, can you hear me?
Can't hear him.
You can't hear you.
How am I going to do this? Do you have a hearing aid?
I have a problem here. Yeah, I can't hear him.
Do you have a hearing aid?
No,
No.
a doctor of mine. It's a long story, okay?
Do you know how to speak sign language by chance, or?
Do you sign language?
Well, wait a minute. Is it just? I don't know how to handle this.
I can't.
Mr. Severinsky, listen to me.
Yeah.
Are you looking at me?
Yeah.
Look at me. Look at me. Listen to me. Can you hear me? I don't know how to handle this.
Nope.
Handle it.
Oh, yeah.
Do we have those?
Oh, yeah, let me see these things here.
That's the best we can do, but I don't think he's going to be able to hear with that either.
Probably not.
All right, let me go on to another case while you're getting that settled. Carrie Lynn Andrew. Lisa, I don't have any idea what to do with Mr. Severinsky. We gave him the ear.
Can he hear now
Pardon?
with the earpiece?
You can.
He was okay at the window, Judge. We just had to speak up.
I can't speak. Sir, can you hear me now? Why are you looking at him? Stop looking at him. Look at me. Look at me. Stay right there. Stay there. Stay there. Stay there. Look at me. Look at me. Can you hear me? Look at me. Why are you looking at him?
Look at him.
Look at me. Wait, time out. Time. Stay there. Stay there. Stay there. Look at me. Look at me. See me? Look at me. Don't look at him. I don't know what to do with this gentleman, Lieutenant. I don't know who wrote the ticket. This is a retail fraud. He can't hear at all.
Okay.
Um,
I'm sorry, Your Honor, what is this gentleman's name?
Severinsky.
Okay.
It's retail fraud. I don't know. Took $34 worth of items. It looks like he's got no criminal history.
I don't see a problem with the city of Woodhaven moving this, Your Honor.
Why don't you go talk to the
Yes,
prosecutor?
sir.
I'm going to hand you the file. I'm not trying to talk anybody in anything. I don't know how else I can handle it. He can't hear me at all. We gave him some hearing aids. This device that's actually better than regular hearing aids. He still can't hear. He must like John because he's looking at John all the time.
I don't like that.
Here, take the file. Take the file.
We'll see what.
All right, thanks. Haley K. Walters. Geez, now I'm talking too loud. Yeah, Haley K. Walters, 25W8377004A and B. 25W836. 837679. Can you hear me, Mr. Severinsky? Look at me. Look at me. Stay there. Stay there. Stay there. Stay there. Look at me. They are dismissing your case. Lisa, I don't know how to convey it to him. He's not listening to me. He can't hear me. I mean, he's
Send him
looking
down here,
around.
Judge. We'll tell him.
I want you to type something out and show him that, will you? Just
Yep,
tell
I
him
will.
your case has been dismissed. Dismissed, case dismissed, motion of the prosecutor. Good luck. Welcome down there. Judge said if he did do this, not to do it again. Okay, Lisa, put that on there too, please. Thank you.
Okay.
Skinner, Krissy Eileen Skinner.
We will go on the record in the matter 25 CF01, State of Wisconsin versus Nicole Britnell. This date appears through Assistant District Attorney Holly Rockow in person. We have Ms. Britnell in person. Her counsel, Joseph Rosenthal, appears by video conferencing. Mr. Rosenthal telephoned my assistant and indicated I'm not sure that this was going to be converted to a status conference. The parties have reached an agreement. Apparently, this was put on my calendar. I'm not certain I did it. She would, or what happened, or why it was on here. It's on as we're here for a status because I don't know what's actually going on. It was set by a plea for a plea in sentencing. It looks like by Commissioner Krupa after she waived her preliminary hearing. I don't know what happened at the preliminary hearing, but what is the agreement that's been reached?
Your Honor, my client would plead to count 5, possession of drug paraphernalia. All other counts would be dismissed and read in. There'd be a joint recommendation for costs only. I would just ask for a plea and sentencing date, maybe about 30 days out, maybe in the afternoon. And I'll plan on being there in person with my client.
Well, I need a strong basis for why this is in the public interest, because we have 2 felonies and we have 5 misdemeanors, and I'm being asked to amend, or excuse me, to dismiss and read in all but one of a possession of drug paraphernalia, maximum penalty 30 days in jail, $500 fine. What is that basis for the public interest, and what is the reasoning?
Your Honor, the amount of controlled substance we're talking about here, including the baggie, I believe was like 0.06 grams. So we're really talking about residue. I don't know that there was any substance left. The
Then that
baggie
hurts my
tested
belly.
positive.
Why do we charge possession of methamphetamine if we're going to be amending to a paraphernalia? Because I'm going to tell you, those charges aren't in the public interest then. They're not in the defendant's interest. They're not in the public interest. If we're going to charge 2 felonies and then in the end reduce them and swipe them all down to a misdemeanor, there's no public interest.
I agree, Your Honor. It should have been charged with misdemeanors. I also don't see that there's any strong evidence for the neglecting a child. The presence of drugs we're talking about here, I think, is the basis. And again, we're talking about residue. So that's why this is in the public interest. As I said, I believe it should have been charged as a misdemeanor for paraphernalia.
So residue is for narcotic drugs, residue for methamphetamine, residue for THC. We're just talking about.
I guess I don't have the weights for the other substances, but we're talking about a baggie that tested positive for meth and fentanyl. The
baggie tested positive for the mix of meth and fentanyl.
I believe so.
Wow.
It did.
I,
It was
I think
field
it was
tested.
maybe, I'm sorry, Holly, I didn't mean to cut you off.
There was a cotton ball that was in a clear plastic container inside of the vehicle. It was field tested. It was positive for the presence of methamphetamine and fentanyl. And so I guess we're talking about the weight of the substance, but again, it's 0.06 grams.
And the THC?
The THC was a yellow waxy ball that was positive for THC. So there hasn't been further testing done, so I don't know any additional details about that, just that there was a yellow waxy ball that was found. Tested positive, I presume with a field test for THC.
Ms. Rocco, you didn't charge this. This is not your criminal complaint, but I will say and make the statement that the district attorney's office carries a very heavy sword, and has the power to not only hold people accountable, but to destroy lives with things that are charged where you do not have either the ability to prove beyond a reasonable doubt in court, or you slash felonies down to a littering ticket, essentially. It makes the public think that our system is flawed and bad. It makes you look bad. It makes me look bad. It makes the system look bad. It makes Miss Britnell look like she is a terrible drug user. It's awful. The district attorney's office carries a very, very heavy sword with their discretion to charge cases. And I understand your reasoning because it makes complete sense when you're telling the weight and you're telling what happened and you're telling that it's residue that's within drug paraphernalia. But charges should reflect what the actual crime is. Even though the law does say that you can, case law says that you could charge them, you can charge them with your heavy sword because the lab can detect a minuscule amount. So then you can charge it for that drug. But that's where that sword comes into play. When you're weighing justice and you're weighing public interest. Mr. Rosenthal, March 21st, 9:15, or what did you say, an afternoon sometime?
That would be my preference. But the 21st looks good, Judge.
I can only do 9:15 on the 21st.
Could we look at the afternoon of a different date? Is that an option? Or maybe even late morning?
I could do March 31st at 3:15.
I've got Washburn cases at 3:30.
April 2nd at 2:15.
Sentencing in Douglas at 2:30.
April 3rd at 1.
That should be okay. I think my last case is at 10:30. That'll allow me time to make the drive.
All right. Okay, so April 3rd at 1 o'clock, you can come and get your notice and then you're free to leave. Miss Duncan, can I see you, please?
Okay, we're ready. All right, this is the People versus Ashley Marie Fountain.
Excuse me, good afternoon, here, Jeffrey Fant on behalf of Ms. Fountain for limited purposes of arraignment. We wait for reading and stand mute.
All right, Ms. Fountain, you have the right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, as Mr. Fanta was appointed to represent you today. You have 2 dates, 2 court dates within the next 21 days. Your first court date will be February 24th of 2025, and that will be your probable cause conference. And you can appear at that via Zoom. Following that, you will have your preliminary exam. Your exam will be on March 3rd of 2025. That will be in person at the 23rd District Court. And on that date, the prosecutor must prove that a crime was committed and probable cause exists to charge you with that crime. As to bond, Mr. Fanto.
Your Honor, I appreciate the fact that the allegations may support a violation of bond conditions on the domestic violence case. And I know the court's position relative to violating those types of orders. I have, as you can imagine, a multitude of problems with this whole thing, but including the arrest, she still has some out county, by out county I mean Tawas and St. Clair matters that they don't pick up on, and she does work with her father in construction. I would ask for a reasonable cash bond, Judge. I would note that she reports that her left arm is in a considerable wrap. That arm is broken. She reports that the hospital said, that to keep it wrapped and hopefully it'll heal, but she should see an orthopedic surgeon. To get advice to see an orthopedic surgeon, that has to be a significant break. And I think she needs, if she's in a custodial manner where she can't meet bond, I think there should be a note somewhere that she needs immediate look at that arm, because if it is in fact broken where the bone is separated, the longer it's left that way is the longer it can create a problem. Having had personal experience with the particular hospital in question, that advice from them wouldn't shock me in the least, and it should be looked at immediately. And she does have a court date set for this Wednesday.
Can I ask, so the other cases are misdemeanors?
It's a DD case.
Okay. So, I mean, this is what Ms. Fanto, I don't know much about the arrest. I heard that it got, there was a resisting and obstructing charge. I'm assuming that it was if you have issues with that.
I do have a ex parte order as well.
Okay. I'm confident that you'll address that. I've signed the ex parte order to preserve evidence. I've also signed the request for a court-appointed attorney. She's currently on bond conditions for an assaultive crime, and she has one place she's not allowed to go, and the allegation is she went there. Not only did she go there, but the allegation is she went there at night, and she wasn't invited in, and she somehow got in a house where she didn't have a key and was standing over someone in their bedroom. Maybe with a screwdriver in her hand. I'm not certain, but that's an allegation that was put on record today. She's definitely a danger to the community. She doesn't follow court orders. She doesn't care what judges tell her to do or not do. So she has $100,000 cash or surety bond with a GPS tether. I will mark the file medical, broken arm, immediate care needed. And I've made a note for the clerks to make sure that it's in bold, all caps, and that the jail is notified via email as well.
Thank you, Judge.
Ma'am, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to go to the property for any reason. You're not to go within, you can't go within a mile of that location. Don't go near it. Your GPS tether, I'm setting conditions that you not go within a mile of that location. And You're not to have any contact. If I find out you are calling him from the jail, sending him emails, trying to use one of the pads to get a hold of him, I will suspend all of your calls. You will not have any communication with anyone except for attorney visits. If I find out you call him or contact him one time, I will revoke all of your communication except for with your attorney. You're going to follow my order. You cannot go to where he lives or works. You can't have any contact of any kind. You can't instant message him, Facebook him, have any communication through any social networking site. You can't send him blank messages. If you go into a store or a party or a restaurant and he's there, you must leave immediately. If he contacts you, do not reply. This is an order of the court. The only one that can change it is the judge. And do you understand me, ma'am? Yes. Is that a yes? Yes. Okay. Cannot consume alcohol or illegal drugs. You cannot possess or have access to firearms. You cannot, well, I think that's plenty. All right, those are your bond conditions.
Judges, if I might, Ms. Fountain, apparently the U-Haul truck keys are in your possession. Would you let the officer know that you're giving your permission to release those to your family? Okay. So your family's here and they'll come next door and pick those up. Okay. And Officer Ziegler, if you'd pass that along, please.
I will.
Thank you.
All right, thank you.
Everybody, good afternoon.
No problem. Sir, what's your name for the record? I like your t-shirt. I think I do. It's definitely not G-rated, but I do like it. All right, Mr. Talley, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond. This misdemeanor matter carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent, and then you say can and will be against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The ticket is 272422. No operator's license on person. The court date will be February 27th for this traffic matter in front of. Oh, no operator's license, uninsured motor vehicle and unregistered motor vehicle. February 27th in front of Judge. Oh, what judge do we have here? Judge East. Now to your main matter. This is case number 230-594-5201. Peterson, Michigan versus Deshaun Talley. Appearances, please.
Thank you, Magistrate. And again, my apologies. Steve Vincent for the people, P71917.
Deliberating on behalf of Mr. Talley, waive the reading and immunity.
All right, the court will enter a not guilty plea on behalf of Mr. Talley. Final recommendation from the people.
Magistrate, I believe as though yourself as well as defense counsel ended up receiving a report that was in my possession regarding this defendant. We have an assault with intent to murder case that's under review. We have this defendant who allegedly is involved in that matter, potentially being charged just based on the allegations. This is a CCW charge. What I would ask for is a tether. I would ask for monitorization twofold. One, because of the fact that we have a case that's under review where this defendant allegedly, based on who we have as being ID'd as a shooter, was involved in that AWIM case. But also, prior to this CCW charge, I have a prior CCW that was deferred under HIDA. He was given 18 months probation regarding that. And And Judge, it was only 9 months after he got discharged that he got picked up with this case. I understand the date of this, but I think just based on the case that I had sent both of you gentlemen, in combination with the fact that he has a prior gun case where he ended up pleading guilty to, we do feel as though there's a level of danger here. We would like to monitor this defendant at least through the pendency of this case, as well as potentially that AWIM case moving forward.
Okay. All right. I did acknowledge receipt of the report. It's from May of last year, and it's been under review for at least 6-7 months now. Is that correct, Mr. Vincent?
It appears as though, yes, Magistrate.
Okay. All right, go ahead, Mr. Reagan.
Yeah, Judge, I appreciate Mr. Vincent in that report. But as the court stated, it's been under review for about 6 or 7 months. This is a case from 2020. I don't know what will happen with that case under review. I don't know if it'll be charged. It may be charged. It may not be charged. I'm not sure. But right now, all we have is a 5-year-old CCW case and a driving on a license suspended case. So based on what we have in front of us, Judge, my client, he works at Buddy's Pizza. He has 5 children. So he's working to try to support the kids. I'm asking that he be given on this case a personal bond. If there is something that does develop at a later date, then that'll be addressed at that time. But as of right now, I'm just asking for the personal bond, Judge. I don't think monetarization on the 5-year-old case is necessary.
I would agree with you, Mr. Reagan. Like I said, it's under review. I know how these things work, and it could be, there's several reasons why it may take a long time. The prosecutor may have asked for some follow-up information. You just never know, or you got the case late. You never know. But as you like to remind me, Mr. Reagan, he's presumed innocent. Is that correct?
Can you hear me, Judge? That is correct.
Okay. So I'm going to give him a $5,000 personal bond in this case. No driving unless you have a valid license. No handguns, firearms, or other dangerous weapons while his case is pending, sir. Pre-trial February, strike that, probable cause February 18th, preliminary examination February 25th, both in front of Judge Taylor. Step aside, please.
Magistrate, thank you for hearing me out on that.
No problem.